The Honorables, the presiding Chief Judge, and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Thank you. Just audio check. Can y'all hear me okay? Awesome. Okay. Well, welcome to the North Carolina Court of Appeals. My name is Chris Still, and I'll be presiding. And we also have Judge Toby Hampson and Judge John Arrowood. We have one case on the calendar today. It's State versus Council. And if the appellant is ready, you may begin and let us know how much time you want to reserve for rebuttal.
Sorry, let's do 5 minutes.
Perfect. Okay.
May it please the court. Good afternoon, Your Honors. Jim Grant with the Office of the Appellate Defender on behalf of Mr. Counsel. Like I said, I do want to reserve 5 minutes for rebuttal, and I also want to thank the court for its flexibility in scheduling this hearing remotely. I appreciate it. I'll get right into it. I think, Your Honors, our position in this case is pretty straightforward and should rest on what are fundamental notions of fairness and due process. If the state is going to convict someone of a crime at trial, it needs to be the crime they actually charge them with. If the state goes to the grand jury and secures an indictment for an offense, it doesn't get to change its mind on the eve of trial and proceed on a greater offense that the grand jury simply didn't return an indictment for. And it certainly shouldn't be allowed to essentially amend the indictment over the objection of the defendant to add additional aggravating elements that were not present in the indictment. And for those reasons, this court should remand back to the trial court for entry of judgment on misdemeanor injury to property, which is the offense that Mr. Counsel was actually charged with. And I think it makes sense to kind of start with the statute we're talking about in this case. It's a relatively new statute. It was passed in 2012. It essentially creates 7 different criminal offenses. And I guess sort of the default offense is a class 1 misdemeanor, which, to paraphrase, essentially makes it unlawful for someone to willfully damage the property of another for the purposes of obtaining non-ferrous metals. That's a class 1 misdemeanor. And then, depending on the absence or presence of additional aggravating elements or facts, that offense can be raised up to different levels. So, for instance, if the value of the damage to the property is $1,000 or more, it's a Class H felony. If it's $10,000 or more, it's a Class F. If somebody suffers injury, it's an A1. If it's a serious bodily injury, it's a Class F offense. If someone dies during the commission of the offense, it's a Class D. So what we have in essence is a class 1 misdemeanor statute that can be aggravated up different levels and classifications based on the absence or presence of additional facts or elements. But the state in this case didn't indict any of those aggravated elements. It just indicted the basic offense. The indictment doesn't allege any of these aggravating facts and elements that I just mentioned. And not to say this would fix the state's issue, because there's case law that says it would not fix the issue, but the indictment doesn't even have a citation to a particular subsection of the statute to where someone could even infer what particular crime they were being charged with over and above what the language on the indictment.
How about the use of the word feloniously?
Sure. So
why wouldn't that trigger like an obligation? Hey, we want more specific, more bill of particulars, whatever.
Well, I think from a starting proposition, it's the state's obligation to charge crimes. It's not the defendant's job to figure out what the state is objectively trying to charge. But let's just take that retort or that position of the state at face value. The caption of the indictment has an F next to the offense, and the indictment language does have that sort of that boilerplate felonious, willfully, unlawfully, or feloniously language. It's long settled, though, that the caption is not part of the charge. We cite that State versus Bennett from 1967 from our state Supreme Court, but there are plenty of cases to that effect. And also Wilson itself, which is the main case we sort of draw an analogy to, specifically rejects that argument. If you read Wilson, Chief Judge Dillon, I don't know if they were responding to something the state had briefed in Wilson or if the court was anticipating an objection on its own. But they specifically say in Wilson that simply because the indictment says something is felonious or it was done feloniously doesn't make it so. You actually have to allege the elements of the offense that would make it felonious. And as I mentioned earlier, not only does the indictment not give you any indication as to which of these 6 or 7 felony offenses the defendant's being charged with in our case, it doesn't even include a statutory citation to where you could make that inference for yourself. So how is Mr. Counsel's lawyer supposed to know prior to trial that the state is subjectively intending to charge him with just the Class H version of the offense, to the exclusion of all the other possible felony iterations of the offense? And the answer is, of course, that defense counsel couldn't know, and in fact didn't know. And I'm not just speculating about that. Counsel's on the record at the trial saying, I don't know what offense you're trying to charge here, and why is it not alleged in this indictment? I have to prepare for this trial, and I don't know exactly what defense or what offense I'm trying to defend against. And I guess our position in a nutshell, Your Honor, is that once counsel pointed this out to the trial court and moved to dismiss the purported felony, which again, there's nothing about this that would lead anyone to believe that a felony has been charged, except the fact that the state at trial is saying, oh, what we meant to charge based on the discovery is a Class H felony. The petty jury can't be instructed on an offense that the grand jury wasn't presented with. And I think this is a bedrock principle of due process because it's been the law for all intents and purposes forever. As our Supreme Court put it in 1940 in State versus Jackson, a defendant must be convicted, if convicted at all, of the particular offense charged in the bill of indictment. Otherwise, what's the point of having a grand jury system at all? What's the point of an indictment at all? If, as our case law notes, in addition to sort of putting a layer of probable cause between the state's desire to charge and the defendant, indictments serve, two primary purposes, one of which is notice. What are you being charged with? And the other is protection against double jeopardy. Look at this indictment. I've already been charged and adjudicated on this charge, when you're pleading former jeopardy. This indictment neither noticed Mr. Counsel was being charged with the Class H felony, nor does it protect him from double jeopardy for that offense, because the indictment just simply doesn't allege that crime or any other crime other than the Class 1 misdemeanor. The Criminal Procedure Act in this circumstance unambiguously requires dismissal. I direct the court's attention to 15A 924E, which says that upon a defendant's motion, the court must dismiss a count that fails to charge the defendant with an offense. And under 15A 952D, that motion can be made at any time for failure to plead a charge. So our position, Your Honors, would be that under the Criminal Procedure Act, the trial court was obligated to dismiss this charge and proceed to the jury only on the misdemeanor offense. And that is why we're asking for a remand for resentencing. And if you look at the State versus Wilson case that I mentioned earlier, which is sort of our closest analog to this relatively new statute, you have a situation where someone is charged feloniously with larceny of $7 worth of property. And in the appeal, the state Supreme Court says, well, he's only charged with the misdemeanor because at the time the threshold was not the $1,000 it is now. I think it was $400. And the Supreme Court said, well, that's not a felony. And it doesn't matter that you're calling it felonious. It's just not, you haven't alleged any of the elements. And it even rejected the argument from the state that you could say, well, the other count in the indictment was for breaking and entering. So you have a breaking and entering charge and a larceny charge. Can't we infer from the fact that he was also charged with breaking and entering that he was guilty of felony larceny, a larceny pursuant to a breaking and entering is a felony? Can't we just incorporate that in? And the court said we can't. And, about this incorporation argument, which is sort of the state's other primary argument at its disposal, there's two problems. The first of which is that there's reams of case law that says the state can't do that. Incorporation is permitted under the Criminal Procedure Act, but under State versus Brown, which we cite in the brief, and several other cases, the incorporation has to be explicit. You have to actually say that you're incorporating by reference the other count. Because if you're not, again, we're putting the onus on the defendant to figure out what the state subjectively wants to charge him with. And that sort of defeats the whole purpose of an indictment, which is to give the defendant notice of what he's being charged with.
Distinguish this case from Singleton.
Well, so Singleton just doesn't apply, I think, Your Honor. We do talk a bit in the reply about Singleton, which was sort of occasioned by the state's invocation of it in its briefing. And I'll concede that Singleton's an important case, and I would even call it a landmark case, and has some pretty important knock-on effects for how we conceptualize indictment defects as a jurisdictional matter. But I don't think that Singleton really has anything to say about this case. Singleton is about the sort of jurisdictional defects, or the sort of defects in indictments that have in the past been considered jurisdictional in dimension. And so therefore they could be addressed at any time, even for the first time on appeal or in post-conviction. And I think the Supreme Court in Singleton, what they're worried about or is concerning itself with is the sort of technical pleading defects that have resulted in the past in defendants being able to get their convictions vacated for the first time on appeal or in post-conviction on what I will concede in some circumstances could be viewed as technicalities, right? But that's just not what we have here. We have a indictment that just doesn't allege an offense. It alleges a totally different offense. And not only is there not—
You're saying here, Singleton didn't really, if you look at Singleton's indictment, literally, it failed to say without, it seemed like a rape case, but they said somebody physically helpless, but didn't say without consent. So,
Right.
So it was clear what they were being indicted for was that they just forgot to put that. It couldn't have been some other crime. That's clearly what it was. In your case, you're saying the indictment does allege an offense, and therefore the state stuck with that.
You've got it, Judge. I mean, that's in essence the argument is once the state elects an offense, it has to proceed on that offense. Now, I understand the state wanted to subjectively try Mr. Counsel for the Class H version of the offense. Again, why the Class H version and not the Class D version or the Class F version or the Class A1 version? The indictment doesn't inform the defendant why they're making that election. And so, our position is essentially not that the court didn't have jurisdiction, but that just under a plain operation of the Criminal Procedure Act, the motion to dismiss should have been granted where the indictment just doesn't allege an offense. This is what the Supreme Court wants lawyers to do post Singleton. I mean, I think Singleton is probably the product of several years of the court finding these jurisdictional defects, some of which were things like omission of elements, which I think is a big deal. But sometimes it was for this sort of extra textual stuff that had been accreted onto the requirements for pleadings over 200 years of common law. So I think we're all in this room probably familiar with the incorporation rule. For a long time, there were a lot of cases about the indictment doesn't say an entity capable of owning property or comma Inc. after, Belk or 7-Eleven or whoever the corporate victim was. And the court had said that it was a necessary element and that the indictment had to state that information in order to survive. In fact, it had to state that information to be jurisdictionally valid. And I think what Singleton represents is the court saying, we're getting away from that sort of hyper-technical, add-on stuff. If you have a problem with the indictment, if the indictment doesn't charge an offense, you should object. And that's what Mr. Counsel's lawyer did in this case. This is not a situation where I'm trying to be clever from my office in Durham. I mean, this is just fundamental bedrock stuff of the way our system is supposed to work. You charge someone with a crime, the state presents its proof of that crime, and then the jury decides whether or not you're guilty or not guilty of that crime.
So are you saying the Superior Court did not have the jurisdiction to try your client for this felony?
I mean, I think you could say that, but I don't think you even need to necessarily use the word jurisdiction. The court had jurisdiction. The court could hear this case. The question is, what offense could it submit to the jury? And our position, I think, is, or not I think, I know our position is simply the offense that is charged by the indictment and any lesser included. We can submit to the jury the offense charged in the indictment and any lesser included. We cannot submit to the jury the offense charged and any greater non-alleged offenses. That's just not how our system works. That's not how our system's ever worked, and nothing in Singleton changes that fact.
So why would not the defendant here be on notice where you're being indicted for a felony? Would the presumption not be that you're being indicted for the lowest level felony under the statute, which would be the Class H? Why, rather than the misdemeanor?
I don't think you can make that assumption. And let me pose a hypothetical. So simple assault is, I think, a Class 2 misdemeanor, and it's a very simple crime, right? You assault someone, you're guilty of simple assault. It's a Class 2, I think. There's also an offense in North Carolina and in many jurisdictions, assault with a deadly weapon with intent to kill, inflicting serious injury, what we call alphabet assault or advocacy. That's a very serious crime. That is a Class C felony. The maximum penalty for a Class 2 is, I think somewhere on the order of 60 days, a matter of months. The maximum penalty on advocacy is, we're talking about a decade or more. So under the state's view of this case, what you could do is have an indictment that simply alleges that I assaulted you. And then I show up for trial and the state says, oh, actually, we're proceeding on assault with a deadly weapon with intent to kill, inflicting serious injury. Or under the version of it you're positing, Judge Hampson, we're coming into court and because it says you feloniously assaulted, I feloniously assaulted you, I have to assume as the defendant that I'm being charged with the lowest level felony. I just don't see how that can hold. I mean, you can't have what's the point of a grand jury system if it's not to make sure that the grand jury is indicting specific crimes?
Well,
I mean,
here,
otherwise
but here the indictment specifically identifies the 1996 red GMC Sierra. Doesn't that provide context and facts sufficient to submit the felony charge to the jury, and then it becomes an evidentiary issue as to the value of the Sierra? Is it enough to meet the felony threshold, or is it purely just the misdemeanor? Is it lesser included?
No, I don't. Respectfully, Your Honor, I don't think it can work that way, because the submission to the jury is based on what is in the indictment. We're adding facts after the fact. So for instance, and here's another issue, right? Is the values here are not different. These are different offenses, and the gravamins of the offenses are different. The larceny. So let me back up a little bit. Your hypothetical, Judge Hampson, also assumes that the defendant is guilty. How, like, well, he knows that it's what if the defendant is not, is just totally innocent and has no idea what the state is talking about when they're talking about a GMC Sierra?
Well, the point though is you can prepare for your defense, right? That's part of the point of the indictment question, and so you can prepare for your defense by determining what the value of the 1996 GMC Sierra is or not, I guess.
Well, it's not the value. It's not the value of the GMC Sierra.
No.
It's the value of the damage to the GMC Sierra. But I think that raises an interesting point, an interesting contrast, Your Honor, is for the larceny, these are two different offenses: injury to property to obtain non-ferrous metals and felony larceny. And the gravamen of those offenses are different, which is why they were charged together and there's no double jeopardy issue. The larceny, the value at issue is the cost of the catalytic, essentially in this case, the catalytic converter. The number value for the injury to property is the damage to that GMC Sierra that the catalytic converter was cut out.
Not the value of the car itself, but what it would cost to repair it. Yeah.
What it would cost, right? That's what I mean. I'm sorry. I'm trying to be precise. The value of the damage to the vehicle.
I understand. I maybe didn't articulate it properly, but I understand the distinction. But it puts you on the argument would be, I think we would hear, is that it puts you on notice of what the damage is to, and therefore you could raise a defense or challenge the state's evidence as to what that value actually would be, if any, I guess.
Well, I think my response to that would be, I think that let's take, I mean, honestly, I don't, that gets into a weird sort of almost upside down where I don't think the actual property is an essential element of the offense. If it just says you damaged property in the amount of whatever, I think that indictment satisfies the statutory strictures. The fact that you're identifying a particular GMC Sierra, I don't even think that allegation is required. So in your hypothetical, Judge Hampson, what you're basically doing is sort of inverting. You're making something that's not required sufficient and something that is required not sufficient or not required. Knowing that there's a GMC Sierra involved doesn't necessarily put you on notice, because you could write on a piece of paper, felony injury to property to obtain non-ferrous metals, and get a grand jury foreman to sign it and hand it to the defendant's lawyer. I'm not sure that piece of paper provides the lawyer in this case any more information than the indictment he actually got.
Because I guess you would equate this with, if I got charged, indicted for assaulting it just says assaulting somebody by hitting them in the arm, But the state then couldn't bring in evidence saying, hey, that injury to the arm was a serious injury, so therefore we're going to elevate this to this felony, blah, blah, just because it identified the arm that I hit.
Right, or to say nothing of importing elements that would be required for the greater offenses that aren't alleged, like, oh, and by the way, you injured that arm with a firearm. Oh, and by the way, you did it like pointing it directly at the person, evidence of intent. So, I think the idea that, I mean, Singleton is important. I'm not going to say that Singleton isn't a huge deal in criminal defense world and prosecution world. It certainly is. I just don't think Singleton applies to this case, and I don't think Singleton has completely absolved the state of its obligation to properly plead offenses. And that's just not my interpretation. The court in Singleton says that. There's a quote in Singleton. It's on page 210 of that opinion. As the Supreme Court noted in that case, quote, the abrogation of the common law rule does not relieve the state of its duty to draft indictments in a manner that satisfies both statutory strictures and constitutional purposes. Nor does such abrogation prevent defendants from obtaining relief if the state fails to effectively discharge its duty. The lawyer in this case, even though Singleton didn't exist at the time this trial occurred, the lawyer in this case did what the Supreme Court now demands of lawyers in Singleton. He objected. He explained why he was not on notice of the offense that the state was subjectively intended to charge. He explained the issue that would cause with his defense and that the ambiguity in the discovery that was troubling him. This is all in the transcript that we cite in the briefing. I don't know what else Mr. Counsel is supposed to do in this circumstance. And I don't think we have gotten to the point where we have eliminated indictments as anything of any substance to where the state can just get a grand jury foreman to sign a piece of paper that states a offense, and then the defendant is on notice for that offense and any greater included, or even just the next closest felony if it's not a felony already. So I don't think we're at that point with Singleton where the rules don't matter anymore. The rules still matter, and the rules especially matter when the defendant has lodged an objection below. And so I don't have much more to add beyond that. I'm happy to answer any questions, but otherwise I'll reserve.
So do you see this as sort of an indictment issue, or do you see it more as sort of a entry of judgment and sentencing issue? Like, what's the offense that judgment could be entered on here, right? And your argument would be at best the misdemeanor, and that's what judgment should be entered on. The indictment adequately charges misdemeanor, and that's all that judgment can be entered on. So is that more of like an entry of judgment sentencing issue than it is an indictment issue?
I think that's a correct characterization. I don't think this is not an indictment defect issue so much as it is what can this jury be instructed on based on the state's indictment. And our position in a nutshell is this jury can be instructed on the offense charged in the indictment and any lesser included. And that's been the law forever. And that is still the law post Singleton. And so therefore we'd ask the court to vacate and remand for resentencing, which we concede there's the judgment should be resentenced. We're not arguing that this indictment is defective, that they should be resentenced on the charge that he was actually charged with. Thank you.
We have the rest for rebuttal. Okay, we'll hear from the appellee now, hear from the state. Thank you.
Thank you, Your Honor, and may it please the court. My name is Terrell Moore with the North Carolina Department of Justice on behalf of the state. Defendant was convicted by a jury of his peers of felony injury to property to obtain non-nefarious metals. Defendant now asks this court to vacate the trial court's judgment because the indictment at issue failed to allege the value of the property that was damaged. This is precisely the scenario that the Supreme Court warned of in State v. Singleton, when it stated that allowing criminal defendants to escape merited punishment based on such technicalities brings disrepute to the administration of justice, especially where, as in this case, and I quote, the indictments are so explicit that the defendant could not pretend that they did not know what they were charged with. Defendant's appeal rests on the proposition that the Supreme Court's decision in Singleton does not apply. However, defendant's appeal fails under either Singleton or pre-Singleton case law. Therefore, this court...
Question for you there. Did the state not concede error before Singleton came out? Is this not the case where the state had conceded error?
No, Your Honor.
In response to a petition?
Are you talking about in Singleton or in this case?
In this case.
No, Your Honor. I don't think the the state has not conceded error at any point in this case. And so, again, the defendant's appeal fails under either Singleton or pre-Singleton case law. I want to start by analyzing this case if this court finds that Singleton does apply. Then I'll discuss how this court should analyze the case if it finds that Singleton does not apply. And finally, I'll discuss why Singleton should apply to this appeal. So turning to how to analyze this case if Singleton does apply. Singleton outlined two types of indictment deficiencies, the first of which are jurisdictional deficiencies. This type of deficiency occurs where the indictment wholly fails to allege a crime. And as we just heard, defendant concedes that that is not the case in this appeal. The second type of indictment deficiency outlined in Singleton are non-jurisdictional pleading defects. This occurs when the indictment fails to satisfy either constitutional or statutory requirements. But critically, under the second category of indictment defects, Singleton requires that the defendant make a showing of prejudice in order to succeed on appeal. Prejudice requires a showing that there is a reasonable probability that a different result would have been reached had the error not been committed. Defendant has not specifically argued this on appeal, and I think the reason for that is that it would be difficult for him to succeed on that point.
Well,
Here,
isn't the prejudice self-evident when you're talking about a Class H felony conviction versus the misdemeanor conviction? I mean, is there not inherent prejudice right there?
I don't believe so, Your Honor, because I think the way that the court would need to analyze prejudice is to say, what would have occurred had the felony been properly indicted? If that value element that defendant contends should have been included was included, would the defense counsel have tried the case differently? Would there have been different evidence? Would there have been different witnesses? And then look at the probable effect of that on the jury. And again, here, the evidence on the value element was overwhelming. The evidence of defendant's guilt was overwhelming. In addition, it's important to remember that this was a 2-count indictment. There was a felony larceny charge that did have a value element already alleged. And so the defense counsel was already prepared to defend against what the value of the catalytic converter was. In fact, the defense counsel did ask questions about both of the officers involved as well as the victim about how that value was established for the larceny charge. The caption also alleged that this was for a felony offense. And so, you know, it's hard to conceive of how the defense counsel's actions at trial would have been different and how the jury would have reached a different result had that error not occurred. And you can compare this to instances where there are cases, for example, where the indictment alleged a different date than the state proceeded on at trial. And this court has found that that did prejudice the defendant because, for example, the defendant was preparing an alibi for a date that the offense didn't occur on. Or you can think of a case where there's a different, standard of care for defense attorneys on certain types of cases where it's typical to call in an expert on one type of case but not another. And that's just simply not the case in here.
Is it the state's position that if the indictment had not included the parens F and just said injury to property obtaining non-ferrous metals, that would only allege a misdemeanor?
Well, I think too, as you already noted, the text of the indictment also did say feloniously, and this, defendant points to the Wilson case to say that that's not enough. But there's a difference between this case and Wilson in that in Wilson, there was a direct discrepancy between the offense alleged, that is, the amount alleged in the indictment was below the felony threshold. And then in this case, there's not. The state's indictment did not say feloniously injured for $200. In this case, it just said feloniously, which should indicate to defense counsel that it was proceeding on the higher amount. So turning past prejudice into whether or not the indictment satisfied the constitutional requirements of an indictment, this court and the Supreme Court have held time and again that the two constitutional purposes of indictment are to give the defendant reasonable certainty of the nature of the crime of which he is accused in order to, one, prepare a defense, and two, protect against double jeopardy. The indictment here satisfied both of those requirements. NC Gen Stat 15-153 just requires that an indictment express the charge against the defendant in plain, intelligible, and explicit manner. In Lancaster, the Supreme Court phrased that differently and said that all that is required are that there are factual allegations supporting the elements of the crime charge, not magic words or rote recitation of the elements. Instead, it's fine if the elements can be clearly inferred from the allegations within the indictment itself. Another way that the Supreme Court has phrased this is in Oldroyd, a 2022 case, it said, the indictment just needs to identify the event or transaction giving rise to the charges. And the indictment here provided the defendant immense amounts of detail about the event or transaction giving rise to these charges. It named the date, the location of the crime, a description of the property that was injured, the name of the victim, and the statute is at issue. In addition, as we discussed, with the caption of the charge and the text of the indictment specifically state that this was for a felony offense. So again, defendant cannot succeed under either of the two categories of indictment deficiency outlined by Singleton. Next, I want to turn to how this court can analyze this issue if it finds that Singleton does not apply to this appeal. As defense counsel noted, this is a new statute, and so neither this court or our Supreme Court have ever outlined what the essential elements of this offense are. But I think that the Supreme Court case of State v. Mustafavi from 2018 provides this court with a good blueprint of how to proceed. In that case, defendant was indicted for obtaining property by false pretenses under NCGS 14-100. Like the statute at issue here, that statute has two classifications of offense. If the amount of property obtained was over $100,000, it's a Class C. If it was less than $100,000, it's a Class H felony. And in that case, the Supreme Court held that the value of the property obtained did not need to be specifically alleged in the indictment. The court emphasized that an indictment couched in the language of the statute is generally sufficient to charge the statutory offense. And there, the court noted that the conduct, which was the subject of the accusation, was charged and provided the defendant with sufficient notice to prepare his defense and to protect against double jeopardy. Another case is State v. Sturdivant, and there the Supreme Court said that the indictment should plainly describe who did what and when. And again, the indictment at issue here plainly identified who did what and when by specifically saying what property was injured, on what date, at what location, all of this giving sufficient detail for the defendant to prepare his defense at trial. And finally, I want to talk about why the Supreme Court's Singleton decision should apply to this appeal. I'll start by noting that this court, the North Carolina Supreme Court, have both already applied Singleton retroactively. This court first applied it in State v. Simpson in August of 2024, and our Supreme Court applied it retroactively not only in the Singleton decision itself, but also in State v. Stewart, which was decided and argued on the very same day as Singleton. Now, part of the Supreme Court's Singleton decision was resting on the United States Supreme Court decision in United States v. Cotton. And in that United States v. Cotton, the Supreme Court also pulled back the jurisdictional common law pleading defect rules. And in that case, the United States Supreme Court also applied that decision retroactively. And so the United States Supreme Court, the North Carolina Supreme Court, and this court have all previously applied the Singleton decision retroactively and have not found any due process clause issues with doing so. Now, there are limited scenarios where applying a judicial decision retroactively can raise due process clause concerns. But, most of the cases cited by defendant are where a court has reinterpreted a statutory offense in order to criminalize new conduct. That's not the case here. Instead, This is reevaluating common law pleading rules. In Measures v. Lancaster, Bowie v. City of Columbia, and Rogers v. Tennessee, the U.S. Supreme Court held that there are scenarios where judicial alteration of prior case law can raise due process concerns, but those occur where that decision is first unexpected and second indefensible by reference to law expressed prior to the conduct. Despite what defense counsel has argued, I would posit that Singleton was not unexpected. As the Supreme Court noted in its Singleton decision, the Singleton decision was part of a long trend of our Supreme Court and this court chipping away at the overly technical, archaic common law pleading rules. While it certainly was a change in prior law, I disagree that it was unexpected. You can look also at the Supreme Court's In re Ju decision issued a year prior to Singleton. There again, the Supreme Court traced the evolution of the common law pleading rules throughout the North Carolina Supreme Court's history and addressed many of the same issues that it addressed in Singleton. In that case, the court said, quote, "This court has been consistent in retreating from the highly technical, archaic common law pleading requirements, which promoted form over substance, and stated that the common law rule is, quote, an obsolete rule that detrimentally impacts administration of justice in our state." And so all of these decisions were coming before Singleton was issued and before defendant went to trial. In State v. Price in 2017, the Supreme Court even outlined the potential for having a categorical approach to indictment defects. So even the new categorical approach was not something that was completely unexpected. It's also worth noting that at the time of the Singleton decision, North Carolina was in the minority of jurisdictions that had kept this common law pleading rule. And in Rogers v. Tennessee, the United States Supreme Court said, quote, "The fact that a vast number of jurisdictions have abolished a rule that has so clearly outlived its purpose is surely relevant to whether the abolition of that rule in a particular case can said to be unexpected and indefensible by reference to the law as it then existed." So again, Singleton was neither unexpected nor indefensible by reference to the law prior to the conduct. Instead, it was the continuation of a long trend of our Supreme Court chipping away at these overly technical and archaic pleading rules. If the court doesn't have any other questions, I respectfully request that this court find that the trial court did not err in denying defendant's motion to dismiss.
I do have one other question, and you are correct. It's another case that I've got where the state had conceded error at a petition point and then changed it when it got here. And on a Singleton issue, sorry, I had the two cases confused. There's another case out there that's on one of my panels that does that. But I have a hypothetical. Let's say if the indictment had said the jurors for the state upon their oath, and the defendant named above unlawfully and willfully did cut, mutilate, deface, or otherwise injure the red 19, would that be sufficient if they don't mention felonious in the indictment itself?
So I think there, again, under Singleton, you need to look sort of at the totality of the circumstances. If there was not an indication in the caption that it was felonious and nothing in the text said felony, then I think that would be a difficult case. In addition, here there's that first count that does specifically allege a value. So all of this was creating a scenario where defendant was being put on notice. And, I think it was the 2019 State v. White decision. There was a dissent by Justices Newby and Morgan where they said there should be circumstances where we can pull outside information into the indictment when we're evaluating whether the defendant was sufficiently on notice to prepare his defense and to protect against double jeopardy. And in that case, Justice Morgan pointed to the arrest warrant itself contained vital information. There was an original indictment and then a superseding indictment, and the original indictment contains the information. And there, Justice Morgan would have held that, all of these factors together made it so that it's clear that the defendant was on notice of the charge for which he was being convicted. And so again, I think what the Supreme Court wants to move away from is us looking at whether there was a specific word or phrase was or was not included in the indictment, but rather what was the defendant on notice of.
Well, I have a question. Like, how does the defendant here know from the face of the indictment, which felony he's been charged with? Because there's a bunch of felonies. That's the question I have.
Yeah, and I think
Doesn't this have to put on notice? This has to put him on notice. It can't be something that happens later. Does this have to put him on notice of what it is? I guess.
Yeah, I was going to kind of pile onto that question too, just to be completely unfair, and ask, what is the highest level felony that the defendant could have been convicted of, based on this indictment?
You can certainly, I think you could certainly conceive of it would be a problem if, for instance, the state were to come in and then allege that someone had been killed during the commission of this crime. But I think here, what you need to look at is first pulling in the information from that first count, which said, this is about the value of the property that was injured. And then also just simply looking at what can be inferred from the language of this indictment. Because again, our Supreme Court has held time and again that it's what can be inferred from the language of the indictment. And would certainly be nothing that you can infer from this indictment that says someone has been injured or killed, but you can certainly infer from, the allegations of what property was injured and when, the value element. And so I think that's how you would have to handle it if that were the case.
Can we read the first charge when we evaluate the sufficiency of the second charge? Are we allowed to do that?
Well, I think.
Has our Supreme Court passed on that issue? Can we look at another indictment when we're passed on the sufficiency on this one? Are we allowed to do that or not? I don't know the answer, but I'm sure there's a clear answer.
Well, I don't think that there is in light of Singleton. I think as defense
before Singleton, were we allowed to look at the allegations of another crime to determine the sufficiency of the allegations of this crime?
No, Your Honor. Under that circumstance, no. Pre-Singleton.
So what in Singleton says that we can do that? We can look at the allegations of one crime to see if this crime is sufficient.
Well, again, the crux of the Singleton decision is what is the defendant on notice of, and so the Singleton court did sort of allude to the weakening of some of the kind of element pleading requirements and the specificity that might be required. But I think it's an open question of what factors can be taken into account and whether or not you can read those other charges in. But I think that it's important here for the prejudice element that the value was alleged in the first count, because defense counsel was already preparing to defend against those value charges or the value piece of information. So again, it's not under Singleton, it's not only has there been an error in the indictment, you also have to establish the prejudice element, and that we would contend the defendant has not done.
Any other questions for the state? Okay, time for rebuttal.
Thank you, Your Honor. So let's hit a few different things. On this retroactivity piece and whether or not Singleton applies retroactively, the court doesn't even need to touch any of that stuff. Singleton just doesn't apply to this case. I think the state would have, first off, I'll rest on the briefing as it pertains to the constitutionality of applying it retroactively. It has been the law. It was before Singleton. It was the law in this case in the state for 200 years that an indictment had to allege the elements of the offense. That's like criminal law 101 in the state of North Carolina. All the members of this panel have been on the court for a long time before Singleton. You're obviously aware of that. To say that Singleton was somehow foreseeable or not a dramatic change in the law is just not an accurate reading of what that case did. But again, it's all besides the point. The state would want this court to hold that Singleton basically held that the rules for pleadings don't matter anymore. And that's not what Singleton holds. Singleton says that indictment defects are non-jurisdictional in nature, meaning that a failure of a pleading to charge a particular element of an offense or to lack some particularized language that the courts have held in prior decisions renders an indictment jurisdictionally defective is not the law anymore. We're just straight, and the premise for that is the passage of the Criminal Procedure Act in the 70s. The court is saying when we passed the Criminal Procedure Act in the 70s, Chapter 15A, we created a whole new regime on how to deal with pleading defects. Well, that's the regime we're operating under, and our argument is operating under in this case. Singleton does not mean that the state gets to play fast and loose with the rules of telling the defendant what it is they're charged with. And the state said that it brings disrepute, quoting Singleton, that it brings disrepute to the administration of justice if this court were to remand for entry of judgment on the offense that was actually charged. I think it brings disrepute to the administration of justice when we just allow the state to do whatever it wants, right? Well, I forgot to allege the element of the value that makes it a felony. So I'm just going to assert on the eve of trial that that's what we subjectively intended to charge. And because the indictment happens to say feloniously, or because it references a related fact in a different count, we can just proceed apace. Nothing in Singleton overrules any of that case law you were talking about.
At what point here did the defendant know that the state was proceeding under this felony?
When he showed up at trial, on the day of trial, and he says,
So he didn't prior to the day of trial enter a plea or anything like that on this charge. Like
I don't know.
is he arraigned on this particular one?
There's no evidence of arraignment in the record. There's no, and we didn't have as part of the record preparation of this case any transcripts of arraignment or anything. But I will say this, the state says there was overwhelming evidence of guilt in this case. One, that's irrelevant, as the White decision and other decisions from our state Supreme Court have said, decisions that have not been overruled by Singleton. We can't incorporate other counts into this count. We can't incorporate the evidence. If you look at State versus Ellis from a few years ago from our state Supreme Court, I mean, the whole concept of indictment validity is based on what's on the four corners of the page. But to the extent the state wants to argue there's overwhelming evidence in this case, there really wasn't. The state's evidence in this case was essentially that Mr. Counsel was seen 20 minutes after a call was made reporting a theft in the area with another individual in a car near the area where the theft occurred. There was never any catalytic converter recovered. They never searched his home. They never found tools that would suggest breaking. They never found this grind saw that was testified to. He's essentially convicted on the strength of an identification by an officer and the fact that he's in proximity to the crime when it occurs. And on
the only evidence here that I'm just reading the statute. Was the only evidence here that the catalytic converter was worth $1,500?
Well, so that brings up an interesting point. The evidence in this case is that discovery, I think, was just a number in a police report. The damage was $1,500 non-specific. When we actually get to trial, what we find out is that the damage is $1,600, or rather that the total repair cost was $1,600, and $1,100 of that was the converter itself, and $500 of it was the damage to the property. Now, there's no sufficiency problem because a theory in the statute allows for the cost of the converter to be considered the damage. So there's no sufficiency problem, but it does highlight this issue of what exactly are you charging him with? On what theory are you trying to charge him with? And that number of what the damage to the property is would have provided valuable information to counsel about the contours of these two charges and how
I'm trying to understand the statute. I'm reading the statute. I'm trying to understand it because it says if the loss of value of the property, or because you could have a car that doesn't have a catalytic converter, but somebody might pay, it might not diminish it by that much. Like a swimming pool does not add value to a house, like what it costs. It says if this is less than 1,000, it's a 1 misdemeanor. But I guess if the applicable one is 10,000, then it's a felony. But that's this, or this. So what if one of them? What if the value of the car just goes down by $900, but the catalytic converter was worth $1,100, like a swimming pool? What's the crime? I don't even understand the crime. I'm trying to understand.
Yeah,
what the
well, I
crime
think
is.
that's what I'm,
And it says or. If you can prove or, it is this crime, or if it's or, but what if he's got two different ones?
that's exactly the point I'm highlighting here, Chief.
So
that
was there
the
any
statute-
evidence as to what the loss of the value of the car itself was based on this? Because it would seem to me if we rule lenity, the state would have to prove all three of them are over $1,000, I guess, because you would have the or.
Right, and the other problem is that because the statutory language is not charged, we don't know the answer to that question, and we don't know until we get midway through the trial and witnesses are testifying about what the actual values were. I did want to briefly, with the very limited time I have left, this issue of prejudice. I think the state is totally misconstruing how we do appellate prejudice. Under 1443A, this is an objected to non-constitutional error. The defendant merely has to show that there's a reasonable possibility of a different result. The prejudice is automatic in this case. If the trial court had not erred, i.e. improperly denied defendant's motion to dismiss, the jury would have only been able to convict on the lesser included. That's per se prejudice. It's not, well, let's replay the trial, and if the indictment had been proper, would the defense had been any different? That's not how we do that. I'm out of time, so I'll just briefly conclude, unless the court has additional questions, and say that this motion, we filed a motion to expedite in this case, and I just want to remind the court of that. If the court would consider an expedited mandate, if it does rule in our favor, that would be appreciated on Mr. Counsel's part, because he is scheduled to be released in July. If he were to get the max on the misdemeanor, he starts doing time in July that he can't do under the law. And that's our position in this case, is that he should be released in July when he is resentenced on this lesser included misdemeanor. So unless, again, there are any questions, I simply ask the court to vacate and remand for resentencing.
That's all I got. Your honors, anything else? You're okay? Mr. Harris, will you adjourn court? Did we lose him? Is John Harris there?
Yes, I'm here, Judge.
Okay. Will you adjourn court for us?
Yeah, I will. This session of the North Carolina Court of Appeals is now adjourned.
Thank you, guys.
Thank you, Your Honor. Have a great day.
You too.